we've tried to do is just be, again, facilitators for you all, and that's really, I think, the great idea that Mamie did behind this event, was just really organically letting you all get together and talk and work through some of these issues, and we're glad to help however we can. This is, as been mentioned many times before this morning, this is a commitment for our department, and so we'll continue to work very closely with all of you over the next several years. Before I actually get started on my presentation, I wanted to take a little bit of time, and I wanted to introduce you. I mentioned earlier, I wanted you to see the people that actually do all the great work that we do. So behind me, I actually have part of our health team from our Consumer Services Division, and these are the folks that when you have problems or questions on health insurance in this state, this is the team of individuals that works so hard for every Missourian. They are very, I tell people, very passionate, very fierce advocates on behalf of consumers in this state. And just by way of giving them super kudos, we're already approaching $13 million in our division that we've recovered for Missouri consumers this year. So again, that just demonstrates the power of these very, very wonderful people who are standing behind me and all the great work that they do. So Carol Hardin is our Life and Health Manager. So Carol is a great person. She's been here with the department for a long time, very knowledgeable, very wonderful and caring person. Sheila Backer, Melinda Rodeman, Charlotte Onstott, and Susie Comstock. And we have a couple other individuals that weren't able to make it back, but I did at least want to give you all some faces with some names and introduce you to my team. So if you wouldn't mind giving them a great hand for all the great work that they do. This is wonderful. Now you'll go back to work. Okay. Well, I'm going to go through this very, very quickly, and I hit the wrong one. There we go. Okay. I'm not going to go through some of the review that I was going to do as far as background of the law, and I'm just going to hit the high points just because we're running a little low on time. I did want to just hit a couple of the consumer protections in the law just so that you're aware of it again. Obviously, with the new law, health plans are prohibited from refusing to sell or renew coverage because of a diagnosis in the autism spectrum. They can't use non-autism spectrum disorder treatments or ABA costs to meet that $40,000 benefit threshold. They can't limit the number of visits to avoid paying the full $40,000 that's under the law for ABA services. And they can't apply coinsurance or copayments or prior authorization standards that are substantially greater for autism spectrum disorders or ABA than they would for other similar services. Big thing that we get a lot of questions on from providers and parents is what is covered, what plans are covered under this law, and what plans aren't. So what I thought I would start off is to try to give you a quick primer back of what the law actually says. And so it applies to all small group and large group health insurance plans that are written in Missouri. And then you'll see here in the next section in blue and italicized, I have some of the others that the law addresses. Small or large group health insurance plans written in other states but insuring Missouri residents. All self-insured governmental plans. All self-insured group arrangements or multiple employer welfare arrangements. And there's a very important part here, to the extent not preempted by federal law. And then also the final is all self-insured school district plans. Now the reason why I have those last ones italicized and in blue is because those are outside of my department's authority or jurisdiction. And so that's very important for us when we're talking about what my department can do for you, can do for your patients, can do for you as parents. That's very important for you all to understand. So that's why I wanted to start off with that. Now, which plans are not covered? Absolutely not covered. Those are federal health plans. So if you have someone who is a federal employee, say they're a postal worker, this law does not apply to them. It does not apply for Medicaid plans, so that's the MC+. It does not apply to the non-comprehensive medical plans. So a lot of times you see the accident or sickness plans, sometimes called limited medical benefit, where they pay just a certain dollar amount of coverage. It does not apply to discount medical plans. It does not apply to the short-term plans. And it also does not apply to the hospital or surgical plans. One of the things that we did very early on, just as a refresher again, is we issued a bulletin because we knew that the providers and parents were looking for guidance on billing codes, because that's been a common issue that has been raised in other states. And we discussed way back last year when many of us got together and talked about our implementation of the law, the fact that we as a department can't mandate or specify certain codes to be used. But what we did do is try to facilitate an information exchange between the provider community and the insurance company so that at least we could get that information out to you a little bit better to maybe hopefully eliminate some of the problems. So again, in the bulletin, we acknowledged and encouraged the use of those 4 HCPC codes, and Ron talked a little bit about those this morning, so those are not brand new to you, I'm sure. And we also encouraged and asked the industry to publicize what codes they would prefer for billing purposes if they're different from those. We also advised the industry that we were going to be watching very carefully to make sure that there were no improper claims denials. So we didn't want to see a lot of regulatory or bureaucratic hurdles being put up in the way of folks getting treatment and denials that way. And then obviously we were very concerned about those children who had already been in treatment plans receiving care, that the new law didn't somehow interrupt those services that they were receiving. So from a regulatory perspective, we felt it was important to let the insurance companies know, if you make temporary modifications to your practices to accommodate these kids, we're not going to come after you, because normally we would, to be quite honest. We want them to be consistent. We want them to follow their guidelines. And so we gave them a safe harbor and said, do what you need to do to make sure that these kids can stay in the treatment plans that they have. If you haven't seen it already, this is our autism resource page on our website. And if you haven't seen it, I would highly encourage you to go out and take a look at that. We did put a lot of information out here for parents, providers, links to other resources, including the Department of Mental Health. So we're trying to get as much information out here to you all as possible. And obviously, if you have suggestions of more information that we can try to do to help you all navigate these processes, we'll certainly do whatever we can. So just let us know. The Parent Resource Center, very quickly, just gives a glossary of common health terminology, provides steps for ensuring insurance coverage for autism treatments. It provides links to complaint forms, and then it also provides links to other autism and health plan resources. What's most important for most of you here today is probably the provider resource page. And it does several things. The first one is, and I talk about this every time I talk to provider groups, is that we tell you, back in March of 2010, this department passed a regulation. And we know that there's this confusion that comes up between someone who's covered under a self-funded plan or someone who's covered under a fully insured plan, which is subject to this department's jurisdiction. So I cannot make a self-funded plan that I have no control or power over tell you anything. But what we can do is ask the fully insured plans in the state that are under our jurisdiction to tell you that. And so what we did is we passed a regulation that went into effect March of 2010 that if the plan is fully insured, that the identification card lists on it clearly that it is fully insured. So that is one tip for you as a provider of knowing this is a plan that is subject to Missouri law, subject to my department's jurisdiction. So if you have any questions on that, obviously you can call back and talk to our staff, but that's something that we specifically did for the provider community to help you navigate these types of claims. Then we also provided links to the provider complaint form. And then finally, we talked about that information sharing that we did, where we obtained information from the insurance companies on how they wanted claims to be billed. So we have some of those surveys, a lot of really good information the carriers provided us in those surveys, and we have all of those posted out on the website. So you could, see those, access those anytime you need. And then obviously, if you have other questions, then we also ask for contact information where you can call each of those carriers directly and get additional information. Oh, sure, please.
Especially on the ID card, I know the person who probably isn't here any longer, but I did think of something that probably makes an impact. Why she got one answer one day and another answer another day. It's called policy renewed, or they went to another carrier.
That's true.
Or they decided they'd go self-funded. So just because you have that ID card in your file on the beginning day of the treatment plan, you want to check that ID card or that coverage decision, whether it changes, because it changes. all the time.
You had a great point, and actually I've got the same point as I go through here, because that's a common problem that we see with providers, is that they'll see someone 6 months and they'll confirm that they have coverage, and then they won't ever check on it again. Well, people in our society, we know you change jobs all the time. Well, employers change health plans, people don't pay premiums, there's a lot of things that can happen. So, and I'll talk about this a little bit more, but you should always, always, always check. Don't just check once, check repeatedly. But good point, Judy, thank you. So when you're talking about billing issues, the one thing that I would tell you just from a regulator's perspective is to do your homework ahead of time. So this is your homework assignment. So the first thing that I would tell you to do is really review that patient's ID card. Now that this law is in effect now, you'll be able to tell very quickly if this is a fully insured plan. Now that doesn't mean that you won't have autism coverage provided under self-funded plans. You could have a card that shows that it's fully insured and it's actually an individual plan. And on individual plans, it's just a mandate. It's not automatically included. So I'm not going to tell you this is a one-size-fits-all and it's going to solve all your problems. But this is one tool that you have to help you clearly understand what's going on. Second thing is to confirm that you are in that plan's network. Because obviously if you're going to treat these people, you want them to know exactly what their out-of-pocket costs are going to be. It's just about letting them be informed consumers. So, and then obviously make sure that there is an autism diagnosis in place, make sure there is a referral from a treating physician, and then obviously we're going to talk a little bit more about treatment plans, but you need to have that treatment plan in place because that is something that they can require. Again, before services are provided, so you've already met them on the initial appointment, now they're coming in for services. I want you to go back and check my provider resource page, look at the information again about that carrier and what they said they needed as far as billing. If you need contact information, to give them a call again. Call the insurance company. Ask for information. Confirm whether it's a group or individual plan. Ask if it's fully insured or self-insured, just to make sure. And then ask where the policy is issued. Because again, if that policy was issued, and I always use the example of B.F. Goodrich. B.F. Goodrich is in Ohio. So if B.F. Goodrich insures its employees in Missouri, but that policy was bought in Ohio, there may not be coverage there. If Ohio doesn't have an autism mandate, there may not be coverage under that policy. So those are questions that I would encourage you to ask. And then the last one I would encourage you to ask is if the claim should be submitted to the health or behavior health unit, because like with Judy and United, they have Optum. So that is a separate unit. You want to make sure when you submit your claims that you're sending it to the right place. If you send it to the wrong place, it will not be paid. That we can guarantee. I would also confirm with them what billing codes they want to be used. We're trying to keep those provider resource pages up to date for you, but while you've got that person on the phone, you might want to just confirm that. Ask them how the treatment plan should be submitted, and if they have any special forms that they would like to be accompanied or accompany that treatment plan. Ask if prior authorization is required. And then if you feel like you're not getting, the best responses, my recommendation is that you ask for a case manager with autism experience. And again, as I told you earlier, one of the providers at a summit that we were at mentioned that build a relationship with that person, because that person will be instrumental in helping you navigate this process, particularly if you're new to the insurance billing world. So, then again, every time you call, document, document, document. Because we want to know the time, we want to know the date of the call, and I want to know who you talk to. And what you know and what Judy can tell you is on the company side, they have great logs. And so when you call them, they make a note of it. And so if you have a problem and you tell me or my staff, we called, I talked to such and such on such and such date, then that's one of the things that we're going to go back to and ask that insurance company. Pull your phone logs. Let's go back and look to see what happened in this phone conversation. So that's very, very important for us to help you. Make sure you submit your request for prior authorization if required. Document your file with the pre-authorization number if you receive it. And then most importantly, again, confirm coverage is still in place when you're providing service. Because again, if you have any lapse of time, that person could change jobs, the employer could change plans. There's just so many different things that can go on. So don't just assume that everything is the same. Call and verify. From my perspective, billing tips that we see, make sure your claim is submitted timely. We talked about that a little bit earlier this morning. Keep documentation of your submission. That's a problem that we've run into with provider complaints, is sometimes they're not keeping the documentation. They're telling us that they've sent it. The insurance company has no record of anything, and there's not anything I can do to help if you don't have that documentation. So if you fax it, if you email it, if you submit it electronically, however you do that, make sure that you have confirmation that it's been submitted. Make sure that it is submitted again to the proper address and the claims unit. Again, if it doesn't go to the right place, it's not going to be paid. Yes, ma'am?
If you have to know that comes by paper, how are you going to have documentation that doesn't make sense?
You know, I've heard some of them say that they'll send it. You know, some providers have been very cautious and they send it by certified mail. I don't think that you have to go to that route, but I think what you can do is you can keep obviously a copy of what you submitted. You can make some sort of notation in the file that this was mailed on such and such date and where you mailed it. And I think that's, if you're still doing paper, that's probably about as good as what you're going to be able to do.
The post office does have a stamp, you know, that they can say, you know, mail on this day. It's not like a postage box, but
Yeah.
with that concern that you've had problems in the past, you might want to do that route.
Right. Yeah, and it really depends. I mean, obviously, I think we would encourage you to try to get electronic as quickly as you can, because that's the way to ensure that you get your claims paid in the fastest way, and obviously there's a lot of proof tied to that. But if you're still in paper, I think if you keep a complete copy, you make a notation in the file of when it was submitted, make a photocopy of the envelope, you know, document any of them that come back returned, that's probably about as good as what you're going to get, unfortunately. So make sure, again, that when you're submitting that bill that you're using the correct diagnosis and procedure codes, because like we talked earlier, if you're not putting that autism code in there, that's, you know, they really need to be doing that. And then finally, make sure that the billing units are listed correctly. A lot of those HCPC codes have different units of measure. So if it's 15, or if it's an hour and you're billing for 5 thinking that it's 15 minutes, you might get that kicked back. So just make sure that you've got the right billing units for the code that you're using. And this is probably the best, sanest advice that I can tell you. You are going to get claim denials. It's going to happen. I would love to be able to tell you that I can tell you how to make sure that every claim is paid on time, every time, and you will never have a denial, but that is not true. So what we can do is give you some tools to know where you can go when those claims are denied, what your resources are, or how to fix those if need be. So we know with the new law, claims cannot be denied on the basis of the treatment or ABA, for instance, being experimental or investigational or based on a pre-existing condition. So we know that's out of the bag. But claims can still be denied for a lack of medical necessity. They can still be denied on incorrect billing codes, lack of prior authorization, lack of timely filing, or if there's a lapse in coverage. So if that person hasn't paid their insurance premium, there's no insurance coverage to pay the claim. So some of these are fixable. One thing I wanted to tell you is starting on July 2nd, 2011, when plans renew, when there's a denial, now the insurance companies have to give you more information when those claims are denied. So it's going to take a while before all the plans cycle through this, but they have to tell you the reason the claim was denied, disclose your rights or the patient's rights to an internal appeal, disclose the rights to request an external appeal if those internal appeals are not successful, and then they also have to tell you about the availability of our services. Yes, Judy?
For external review, it cannot be sort of like an administrative denial or something, does it have to be like an adverse determination?
Adverse determination, great point.
That's
Yeah, if it's being denied on lack of timely filing, that's not eligible for external review. And I'll talk a little bit more about external review later, but that's absolutely right. And if you do receive a denial, someone mentioned earlier, appeal, appeal, appeal. If the denial is based upon medical necessity, you can appeal. You have, for group plans, 2 levels of internal appeal. For individual plans, you have 1. And so this internal appeal process is your opportunity for a full and fair review, again, by a different group of individuals to look at it again. It's also an opportunity for you to provide additional information about that claim if necessary. So, and again, what appeal rights does my patient have? Individual 1, group health plans 2 years. And when you submit an appeal, the plan has to provide a response to that appeal within 30 days. Other denials, not so helpful. Incorrect billing codes, if you get those, you need to correct those and resubmit it ASAP. If it's prior authorization, or if it's a timely filing issue, if you have documentation that shows that you obtained the pre-authorization or that you were told that it wasn't required, or you submitted it and you have proof that the claim was submitted and it's still being denied, file the complaint with us, provide that documentation, and we will contact the plan and see if we can get that worked out. Now, external reviews, that's sort of a different thing. External reviews is a service or a process that is available to consumers once those internal appeals have been exhausted. So in Missouri, external reviews are available for claims that are denied because of medical necessity, experimental, there's a question on the efficacy of the treatment, or if there's a question about the level of care. So this is a final review that is provided by an outside medical expert, and that process is actually run right now, at least, and hopefully continues, by our department. So we actually, when your patient goes through those internal grievance and appeals, they're unsuccessful, you know that this is their opportunity, they need to make an external review, you need to get them in contact with us, have them request that external review. We put the file together, we send it to the outside expert to review, they render a decision to us, and then we then pass that on to the patient and the plan. And unique for Missouri is that there is no cost to the consumer for that external review. That is a cost borne by the department. Yeah, Gay?
If a treatment plan specifies ADA comes from medical necessity, is that all that is required to prove medical necessity, or is there additional documentation?
Well, I mean, each of the plans have their own guidelines for what medical necessity is. But this is where external review really comes up, is that if the plan's medical guidelines and the staff people look at those treatment plans, and in their view, that treatment plan hasn't rose to the level of meeting medical necessity for that particular patient, and you go through the internal appeals and that decision is continued to be upheld, then your patient can come to us, request external review. We will have that independent outside medical expert review that same information. They will then make the decision based upon the information in the file whether or not it is medically necessary. And if they overturn the carrier's decision, then we then order the carrier to go ahead and provide service. So it's just a continuum of processes that you're going through with these appeals and then external review.
Can I interject that?
Please.
Since ADA services are very fluid and they're growing all the time, all of our medical policies are updated continuously on whether or not that treatment would be considered medically necessary or effective for that purpose. So it is an evolving thing to determine medical necessity. And there are experimental and unproven types of services that we do not pay for.
Great clarification. So access for external reviews, because we don't handle external reviews for all plans, that's very important. So in the state of Missouri, if you have someone who's covered under a self-funded plan, that external review is either going to be provided from the plan itself, or it may have to go through the Office of Personnel Management through the federal government. Now, if it is a fully insured plan, That will come through this department. We handle those external reviews. If you have a plan that is fully insured, but it's issued in another state, that external review is going to have to go through that other state's Department of Insurance. If you run into those, we can get you in contact with those other departments of insurance so that you can maybe have a little bit easier time navigating that process. The other unique thing to external review in Missouri is that we do not have a time limitation. In some states and under the federal law, it's a 4-month period after the last administrative denial on the appeals that you must file a request for external review. Missouri is a little bit more consumer friendly. We don't have a time limitation on that currently, so we think that's a very good thing. Just background, when you send in a request for external review, the eligibility is actually determined by us. We'll look at the claim files. We'll take a look to make sure it is falling within those guidelines I mentioned earlier, medical necessity, experimental efficacy, level of care. If we determine that it is eligible, we'll notify both of the parties. We'll ask for additional information that they would like to submit to the reviewer. We do send that to the IRO. The decision is binding on both the patient and the plan. And the reason I put that in there, and I think that's very important, is that you as providers cannot request external review on behalf of your patient. This is waiving some of their legal rights. Those decisions have a right for limited judicial review once the department's review is done. So those requests really do need to come from the patients themselves. And when you submit an external review on a standard basis, not an expedited, we do get those responses and decisions back out within 45 days. So it's not the fastest process, but it's actually a pretty quick turnaround. So how can DIFP help you? Well, with fully insured plans, we can help with complaints as to compliance. We can provide assistance with internal appeals, and then we can provide assistance with the external review process. Now, as far as self-funded plans and out-of-state plans, our role is more informational, to be very frank. We can contact the plans. We can try to get as much information we can as to what's going on or why there's not coverage, but it really is very limited. But what we can do is we can provide assistance with those internal appeals through those self-funded plans and plans issued in other states.